consider a prescribed oath to be binding on your conscience?
I do, my lady.
Do you then swear that the evidence about you shall be the truth, the whole truth, and nothing but the truth? If so, raise your right hand and say, so help me God.
So help me God.
Witness is sworn, my lady.
Thank you very much. You may take a seat, sir, if you so wish.
Thank you, lady.
My lady, there's no exception here to the order made in regard to the media publication. The witness does not wish to be televised.
Hold on, I don't get it.
So it's no exception. The defence witnesses would not be televised, and there is no exception to that.
Oh, I see.
So yes.
So the order stands.
Yes, the order stands, madam.
Yes, this witness should not be televised or his image published in any form. Thank you.
Dr. Versveld, you have before you a document marked as RR1 and then RR2 and RR3. Just for purpose of your evidence, let us just identify what the document is. RRR1 is your curriculum vitae, is that correct?
My lady, mine are PP.
Yours will still be PP. We have since received different documents, we had to renumber it. So you can just change the P to R. The RRR1 would be your, that is in fact your curriculum vitae.
That is so.
RRR2 is your report.
Yes, my lady.
And RRR 3.1 to 3.4 are X-rays.
That is so, my lady.
Now, can we start with your qualifications, Dr. Versveld?
Yes. I think if we go to the section that is relevant is my professional appointments, that's section 3. And this outlines, my lady, the progress of my career in medicine, in orthopedics and medicine. And what it shows is that after I qualified, I became an orthopedic surgeon, and in 1978 I was head of the Department of Orthopedics at Weskoppies Hospital, and then became in 1987 Professor of Orthopedic Surgery at the University of the Witwatersrand, and then in 1988 head of department of the orthopedic surgery at the University of the Witwatersrand, and then went into private practice at the end of 1989, lady. And I've been in private practice since then, doing private clinical practice and impairment and disability evaluation.
I see that up to February 2011, in relation to appearances court, you have appeared 14 times, but since then, since 2011?
Yes, I've appeared many times since then.
And the doctor-patient relationship started with Mr. Pistorius?
My lady, he was a small baby when I first saw him. He had congenital deformities affecting both of his lower limbs, and I saw him and advised his parents on how to treat him, and eventually treated him for his condition.
And is he still a patient of yours?
Yes, my lady.
Now, Dr. Versveld, if we go to your report, RR2, to page 2 thereof, the present situation is that a summary of the history received from the Mr. Pistorius himself.
Yes, my lady. This is what I would call the medical history that Mr. Pistorius gave me.
And when was that given to you?
Well, the date of this report is the 7th of May. It was
2014.
2014.
So it was around about that time.
Around about that time, my lady.
Could you then go to page 2 and just deal with that?
My lady, this is what Oscar Pistorius has told me. I can stand with my knees straight and put weight on my stump on the right side when I'm not wearing my prostheses. On the left side, I have to move the pad around to stand on it. And in brackets, the pad rolls off the end of the stump, close brackets. If I'm not concentrating, it can click, and it is extremely painful. If I put the left stump in the right position, I can stand on the left leg and put the right leg forward, but there is discomfort and insecurity. I have to bend the left knee to put weight on it. If I don't do this, the heel pad clicks out and I can't put weight on it at all. When I'm standing, I can't stand still. I have to move the stumps around. I can't stand for long, in brackets 1 to 2 minutes. Then the weight starts hurting. On to page 3, my lady. It is better on a soft surface and worse on a hard surface. My balance is better in the light. In the dark, I really struggle. At night, if I get out of bed, I hold on to things. If I'm standing and I'm pushed, I will tend to fall over. If I put sudden weight on either stump, the pad will move backwards. It clicks and it is sore. This is more sore on the left side than the right side. I struggle to carry something when I'm on my stumps because I struggle to balance. I need my arms to balance. I fall often. If I click that stump, I fall to the floor. It's like a shock of pain, and it is really painful and lasts for about 15 seconds. The pad goes back when the weight is off. When this happens, I grab the stump and squeeze it, and it gets better. I fall mostly because of the left stump, but also because of the right stump. I fall about once a week or once every 2 weeks. If I get out of bed, I can just fall down. If the bed is a different height, when I put the stump down, I can fall down. At night, I will go to the loo without prostheses, but I don't go into the house without prostheses. I can't reach for things. I can't move quickly. The dog can knock me over. In brackets, the dog has knocked me over many times. I bath rather than shower because I can't stand long. I have a bench in my shower. I can't stand and wash myself in the shower. I have slipped lots of times in the shower. If there is a small mosaic in the shower, I can't stand on it at all. When I have no prostheses on, I need to bend the left knee and put the left stump down so that the outside of the stump is in contact with the floor. I have to bend the left leg and walk with my back bent. If I walk without prostheses on a small stone or a crease in the carpet, it is painful. I can't stand on brick paving, even a small inequality or stone, and I'm in trouble. If I turn round, I shuffle. I have to be careful as the bone moves and the stump could click out. I get back pain if I stand on my artificial legs. If I stand for about an hour with my artificial legs, my low back becomes sore, and shortly after that, my stumps become sore. If I race and I have to do an interview on those prostheses, and I'm on them for more than an hour, they feel constricted and tight and throbbing. If I'm standing with my prostheses on, I have some balance if I'm pushed from the side. If I'm pushed from the front or the back, I don't have much resistance. The following, my lady, on page 7, examination findings. These are my clinical findings, my lady. His stumps measured 28 centimeters long from the medial joint line to the tip of the soft tissue. That is the medial joint line of the knee, my lady. With the patella pointing forward, the stump was rotated inwards by 20 degrees on both sides. In brackets, when he walks with the prostheses on, his knees are turned out by 20 degrees on both sides. The above heel pad circumference on the right side measured 16.5 centimeters. The above heel pad circumference on the left measured 18.5 centimeters. The heel pad circumference measured 18.5 centimeters on the right side and 19.5 centimeters on the left side. The heel pads exhibited considerable mobility on both sides. On the left side, it was possible to move the heel pad from the anteromedial, that is from the front inside, to the posterolateral, that is the back on the outside, and this resulted in a snapping or clicking out of place of the soft tissue, which resulted in pain. Pressure over the distal end of the lateral side of the tibia resulted in pain on the left stump. There was a scar measuring 9.5 centimeters over the back of his right calf, above the heel pad posteriorly. There was a scar measuring 6 centimeters over the back of his calf on the left side posteriorly. There was anterior bowing of the right distal stump measuring 12 degrees. There was anterior bowing of the left distal stump measuring 12 degrees. He walked with his left knee bent, his hip externally rotated, and the stump tipped inwards, in brackets, to get the weight on the outside of the stump, close brackets. When he put weight on the left stump, the knee buckled. Because of the bent left knee, his left leg was shorter than his right. He walked with difficulty without holding on. At that time, he was on Marley towels in my consulting room. He could not walk on the industrial carpeting. When trying to stand without holding on, he had difficulty standing and was moving all the time. The biggest stride he could take, bearing weight on the left stump while holding on to something, measured 23 centimeters. While holding on to something and bearing weight on his right stump, the maximum stride he could take was 33 centimeters. The left leg actually buckled when he put weight on it. When standing or walking, he was bending his back forwards. My lady, there's a typographical error here. Standing on his stumps, he measured, this should be 1.5 meters tall.
1.56 meters, not
1.56 meters.
Yeah, it's
tall.
not 1.56 centimeters.
Correct. In walking stance, he measured 1.44 meters tall.
Again, the centimeters was just deleted. Must be meters.
When standing in his shoes and prosthesis, he measured 1.86 meters tall. He weighed 73 kilograms when not wearing his prostheses. It was difficult to weigh him because he was unable to stand still on the scale without holding on. He weighed 79 kilograms wearing his prostheses, fully clothed and in shoes. He had a bruise measuring 4.4 centimeters by 3 centimeters over the lateral aspect of his right mid-thigh. At this time he said that if he stands on grouting between the tiles, this hurts his stump. My lady, we then go on to special investigations. And x-rays of his lower legs were taken on the 10th of May 2014, and the radiologist's report is enclosed. But what I would like to do at this point, my lady, is to show you the x-rays. And that is triple R 3.1. Now, this is a photographic representation of the X-rays. The original X-rays are here in court, but I thought that this would be the most appropriate way for you to visualize what I'm trying to explain, my lady. The first picture is 3.1. That is what we call a lateral view. In other words, you are looking at the side of the knee and the stump. And this is the right side, and the right, the indication with the letter R is on the front side of that stump. That's just to orientate you, my lady. Now, if you look at this picture, you can see that the stump is curved. It's not straight. There's a bend at the lower end of the stump. The second thing is that it is a very small end of the stump that is there. Now, if you look at this X-ray, my lady, the heel of the foot is visible if you've got a little bit of imagination. At the back, there is a bulge, and in that bulge there is a piece of bone. And that is actually the remnant of the original heel, and that bulge at the back of the stump is the heel pad. So although the object of the original surgery was to get the heel pad completely under the stump, at this stage the heel pad is in fact behind the stump, and although there is some heel pad material under the stump, it's not complete. Then we go to 3.2. This is now what we call an antero-posterior X-ray. That means we're looking from the front. Now, on this X-ray, the R is on the outside of the knee, the lateral side of the knee. Now, normally there would be two bones there, my lady. There would be a tibia, that the stump is the tibia, and next to it would be the fibula. But in his case, there was no fibula because that was the condition he had. He had fibular hemimelia, which involves the tibia being absent, not present. Now, if you look at that stump, you can see that the stump curves with the curve on the inside, but the stump, the end of the stump is going to the outside, my lady. Now, I'd like you to please keep that picture, that is RR 3.2, and then look at the left one, which is RR 3.3. And if you can have the two next to each other, you'll see, now on this case, the outside of the knee joint is where the L is, and that's where the fibula would normally be. Now, if you look at that stump, you can see that the heel pad material has gone to the outside, and on the inside, the stump, the tip of the bony stump, doesn't have the protection of the heel pad material. Medial side, and then the outside would be the lateral side. So the inside of the leg would be would be where the two legs come together.
Okay. What I want you to do for me is just to show it in the picture itself, so that I should know whether I'm following properly.
Yes.
Yes.
My lady, where the L is,
Yes.
that is on the outside of the leg.
Thank you.
So the inside is on the other side.
Thank you. Yes, you may proceed.
So if we go to the final picture, which is R 3.4, you again see the bowing of the tibia, and again you see how very small the end of the stump is, my lady.
Yeah. Dr. Versfeld, in consultation, you indicated that before you get to the discussion, that you were of the view that it would greatly assist the court if you can show the stump, demonstrate on Mr. Pistorius to the court the stump, to show the mobility and to show the heel pad and to show what you can't always see on the x-ray photos.
Yes, my lady. With your leave, I would like to actually demonstrate the situation of his stumps, my lady.
Yes, please.
Lady, so I would ask just for a very short adjournment to give him an opportunity to just be appropriate. And then I would ask the court maybe not to go up, but like with the Captain McGenna with the test, also to come to a place that's maybe near the microphone, just that he can do the demonstration. It would not be possible to see from where you're sitting, if I may. It would only be a 5 minutes.
Court will adjourn.
Hulle is nog bezig, Dani. Hy gaan jou nou weer 'n lykie gee. Dani?
Oscar Pistorius in the dock, days after he shot and killed Reeva Steenkamp. One person never saw this day. She was the woman Pistorius arguably loved the most. Meet Sheila Pistorius, Oscar's mother. When the superstar athlete was just a young boy, he had no Pistorius in the dock, days after he shot and killed Reeva Steenkamp. One person never saw this day. She was the woman Pistorius arguably loved the most. Meet Sheila Pistorius, Oscar's mother. When the superstar athlete was just a young boy, he had no idea the time with his mother was running out.
Okay, now it's time to sing.
This rare footage captures Oscar sitting next to his mother and brother Carl, celebrating a friend's birthday.
Happy birthday to you, happy birthday to you, and the best year you ever had.
Oscar is smiling and mischievous, encouraging his friend to shove his face into his birthday cake, and then doing the same.
This is the grossest, most grossest birthday party I've ever been to.
His mother doesn't scold him. She joins in. Gillian Silcock clearly remembers these moments with Sheila Pistorius, a woman she regarded as her best friend.
She was just a normal mum who loved her kids, fought for them, fought medical aids, got Oscar prostheses, grew with him.
My lady, two things. The first is that I understand there's some request for photographs, but it cannot be because this witness is protected against photos, and it's still part of the defense case because he's going to do the demonstration. So we'd just like the court to confirm.
Okay, the demonstration itself is also not to be photographed or filmed.
Thank you.
Thank you.
My lady, may I then seek an indulgence for the court and ask the court if it's possible for the court, like in the previous case, to come down to maybe in the vicinity where the witness is so that we can do the demonstration. It's unfortunately not possible to do it over the distance.
No, it's no problem at all.
Gou weer vir ons, Dani.
Maybe, Dr. Fassett, if I may ask you if we can move the chair forward to be closer to the microphones, please.
I'll demonstrate and then I'll tell.
Will you do that? Thank you.
Ek hoor jou, Dani. Ons het net 'n probleem met daai geraas van hy server. Want dit het 'n impact op ons transcriptions.
Lady, what I wanted to show you, and which I will tell you to the microphone, is the instability of the soft tissues of his thigh. If you consider your own heel, you know that the heel is very firmly fixed to the bone. So this you can see that the soft tissue is very, very mobile. And what is happening is that because the main heel pad is at the back there, if the foot is put down in the incorrect position, the heel pad slips backwards, and he puts the weight on where there is no heel pad, and therefore that creates pain, and instability, and it often causes falling. Now, if you look at the left one, this is the one that is the most of the problem, is that the heel pad has slipped off over to the outside completely. And here, I don't know if you can see, but he is actually moving because that is sore. And you can buy, if you put the weight down incorrectly, what you do is that soft tissue snaps over the end of the bone and creates severe pain that causes him to fall down. Now, what are you doing when he's walking? Let's maybe give a summary then. What I've shown, milady, is that on the right side, the soft tissue over the end of the stump is very, very mobile. And if you compare that with a normal heel pad, where the structure of the soft tissue is such that the heel pad is very firmly attached to the underlying bone. This is not the case here. So the soft tissue actually can slide out underneath the end of the bone. On the left side, if he puts the stump down straight, the soft tissue slides past the end of the bone, and that it actually snaps. You can elicit the snap, but it will cause him pain. And when that happens, he can't bear weight on the stump and he falls down. So what he's doing when he's walking, what he's doing is he bends his knee and then turns it in like that so that he can put weight here where there is heel pad underneath. So if he stands with the leg straight like that, the heel pad simply slips off and it causes him severe pain and falls down. Lady, is there anything more you'd like to see?
Is that all?
That is all. Thank you.
Thank you.
Thank you
very much.
Milady, what I have demonstrated on the left side is that...
Doctor, if you can just wait a small second.
This was just for the record.
Small second.
Okay.
Excuse me. Before you go up, can we just quickly put his clothes on? Otherwise you have to go up. Thank you. Just a short adjournment. Hey, madam, start your rising up through money.
Thank you, ladies and gentlemen.
She just wants to hear it when you put it in the record.
kitchen window, and Carl was playing around, and Emmy was toddling around, and Oscar was stomping around in the dog's bowl. And she shouted out of the window, "Oscar, get out of the dog's bowl, you're wetting your feet." And then she realized that he didn't feel that, so she just said, "Oh, carry on in the dog's bowl, Oscar."
Silcock describes Sheila Pistorius as a committed Christian and a caring mom. But as this footage shows, she was also free-spirited and fun. The tragedy of what would unfold was still years away. Underneath the smiles and laughter, Sheila Pistorius was privately coping with being a single mom after her marriage to Oscar's father, eNCA, failed.
She said one day, Henk came to fetch them for the weekend, and I saw them drive away. She said that really broke her heart. It was a difficult time, very difficult time, and I don't know if she ever really got over the sadness of a broken marriage. It's a sad thing to go through. But I'll tell you what she did. When there was no money, the children didn't ever really know, because she made things fun.
I'm a Barbie girl in a Barbie world. It's fantastic.
Crept on tiptoe to the mighty wall and grabbed the mirror off the wall.
This footage shows Sheila Pistorius acting in a play at the Allen Glen High School, where she was employed as a secretary. She organized Christian raves and foam parties.
Please, Mr. Potpourri, come to take a joke. It's only March and we very moving. All we do is order it up, work and graft and go along when all we want to do is just rest a while.
Sheila Pistorius wrote letters to her children throughout their lives. Oscar Pistorius would begin his 2009 autobiography, Blade Runner, with an excerpt from one of them, written to him just 5 months before surgeons performed bilateral amputations on his legs. He spoke about her words to him during an interview with eNCA's Pat Pillay.
The real loser is never the person who crosses the finishing line last. The real loser is the person who sits on the side, the person who does not even try to compete. And of course, you're quoting your mother.
Yeah, I mean, she was a really strong, pivoting point in our lives, and she really, made the point of saying, if you want to do something, go, into it full-heartedly, even if if you don't succeed at it, try a couple of times, and if you don't succeed, you can look back at it and say, well, that really wasn't for me, but you don't have to have a regret at the end of the day. And that was something that she really believed in. If you didn't get involved, then you're missing out. But if you got involved and you still didn't succeed the way that you may have had expectations to, then you've still achieved something in giving it a go.
Oscar Pistorius would write that he and his brother and sister were brought up with an iron rule, never to say, "I can't." A radio interview recorded when Oscar was 14 reveals her deep faith in God and her pride in all her children.
Oscar has a well-rounded personality and a fabulously positive outlook on life, with a good self-image, which certainly rubs off on everybody around him. He's been a tremendous source of encouragement to many people, ranging from diabetics who've had to have their legs amputated, even depressives, amputees, and even a lifesaver in Plettenberg Bay whose leg was severed off in one of South Africa's most vicious shark attacks 3 years ago. And he's just a very popular, well-respected boy, and I certainly deem it a privilege to know him and be his mom.
Sheila, you must be immensely proud of Oscar.
Yes, I am. I'm very proud of him and my other 2 children as well. They are fantastic children, and I really thank the Lord for everything that he's done for them and that he's going to do in their future.
Thank you for the indulgence, my lady. You were about to put on record the last demonstration.
My lady, what I demonstrated on the left side was that there is quite marked tenderness over the end of the stump, and the soft tissues, the heel pad itself, if he puts the leg down straight, those soft tissues migrate to the outside and towards the back, and that actually you can actually elicit a snap, which is what he describes, but you can actually clinically elicit that snap, but it is very painful for him. I think that to get a clear picture of what I'm saying, if you could go back to RRR 3.3, my lady. That is a AP X-ray, anteroposterior X-ray, and the L is on the outside of the leg. Now, if you take that picture and tilt it so that the PP rotates to the right side, and then you'll see that if you put that stump down on the ground, that there is a nice covering of soft tissue under the stump. But if it is completely straight, my lady, that the actual heel pad material moves to the other side with a snap, as it happens, and then causes him pain. But that's what he's doing. He's tilting that leg so that he can get that protective soft tissue underneath the stump when he's standing. But that is very mobile, and if he puts that stump down in any way skew, that tissue moves out under the stump and can result in him falling on the ground, my lady.
Thank you, Doctor. Can we then go to page 11 of your report?
Discussion. When walking or standing on his stumps without holding onto something, Oscar Pistorius finds himself in a situation that he is in danger of falling. He can walk for short distances without holding on, but he needs his hands and arm movements to balance himself, and has very limited means of rectifying the situation should he start falling. That is because he can only do very small strides, and he has to put down that stump in a very particular way. Whether standing or walking, he has to place the left stump in exactly the right position, or the soft tissues click out of place and cause him severe pain. He falls often because of this. His ability to turn around is severely impaired by his lack of balance and the instability of his stumps. On his stumps in a dangerous situation, his ability of fleeing is severely impaired, and his ability to ward off danger is severely impaired. Conclusion. On his stumps, Oscar Pistorius has serious difficulty walking or standing without support. Even with support, his walking is severely impaired by the small size of the bone ends of his stumps and the soft tissue instability of his stumps, and he can only do this for short periods of time. He has to place the left stump in a very specific position to bear weight, or the soft tissues click out of place, and this often results in his falling to the ground. His ability to turn round is severely impaired. On his stumps, he is seriously vulnerable in a dangerous situation, with a severely impaired ability to flee, severely impaired ability to ward off danger without a weapon, and in danger of falling should he put the stump down incorrectly.
Now, Doctor, two things. The one is that there was evidence by Colonel van Meelen that in his view that there was damage caused to the door, and the common cause evidence is that Mr. Pistorius struck the door with the cricket bat a number of times. On his version, Mr. Pistorius, he had his prosthesis on, but the Colonel van Meelen, to some extent, in the beginning, his evidence was that, in his view, he struck the door with the cricket bat by holding the cricket bat with both hands and then struck the door quite hard. What is your view about that?
Milady, when he's carrying something, he has difficulty balancing. But if he's carrying something or holding something with two hands, he has a severe problem with balancing because he's using his hands to allow him to balance. So while I would expect that he could carry a cricket bat, that would probably be in one hand, I don't believe that he would be able to strike anything with that cricket bat with any type of force with two hands, because he would overbalance and fall down. He may be able to, using the one hand to balance, he may be able to hold the cricket bat in one hand, but that would be very, very limited, because if he swung with any force, he would tipple over, my lady.
Then, going to page 3 of your report, it's something that I think, if you could explain that to the court, where it's in the present situation where you were told, and I quote, "My balance is better in the light, in the dark I really struggle." Why would that be? Why would there be a difference between light and dark?
Milady, we have, all of us have in our joints a thing which is called proprioception. There are nerve endings which tell the brain where that joint is in space. So that if you are standing in a dark room or standing with your eyes closed, you can balance because of the proprioception in the joints, which tells you that you're standing upright and you're not falling down. But in his case, the proprioception of the ankle and foot joints is missing because they're not there. And so therefore, he has to rely on sight to be able to balance. Yes, he's got proprioception in his knee, but he's balancing on the end of those little bony stumps with an unstable soft tissue underneath those little bony stumps, and there is no proprioception of there. So therefore, he will fall if he hasn't got some sort of visual reference.
And then he also told you about him falling from time to time. Could you find any evidence of that?
Yes. If we go to my examination findings, on page 10, milady, the second paragraph from the bottom, he had a bruise measuring 4 centimetres by 3 centimetres over the lateral aspect of his right mid-thigh.
What did that indicate to you?
Well, that was a bruise. That was a bruise that was present, and he had sustained in the fall a few days previously.
Thank you, my lady. I have no further questions.
Thank you very much. Yes, Mr. Mel?
Professors, Dr. Versveld, the accused was referred to you by his lawyer, if I read your report correct.
That is correct.
That happened in May 2014.
Yes.
You know that the accused by that time has already testified in court.
That is correct.
You followed his evidence?
I have not.
You did not follow the accused evidence at all.
The day-to-day court proceedings I have not followed. I have seen clips on the news, and I have seen snippets here and there on various programs, but I have not followed the detailed court proceedings.
I had a good idea of the accused version.
Yes.
Good. Because, you see, Doctor, his cross-examination was finalized on the 15th of April. Will you accept that? And you saw him on the 7th of May.
If you tell me it was finalized on that date, I'll accept it.
Now, we had Dr. Foster testified that the accused, when she saw him also in May, he was depressed. And the accused also indicated that he was under medication for depression when he saw you even. You don't know.
That could be.
We have reports from a panel that was handed into court this morning that in the one report, it still has to be proven, but in the one report there's an indication that the accused is suffering from post-traumatic stress after the event. So you saw a person that's already given evidence, already given a version, and was suffering from depression. You will accept that?
Yes.
Good. You've seen a person for whom it was very important to indicate severe vulnerability and inability to walk. What do you say if I tell you that?
I can't dispute that. I think that's fair.
Good. Then, do you know can I ask you if you follow this evidence? Do you know the accused's version about what happened that night?
No.
If I look at paragraph page 2, 3, 4, 5, 6, and first line at page 7, my impression is that that's what the accused told you.
That is exactly what it is.
Yes. At RRR2, that's what the accused told you.
Yes.
And then you have your examination findings, discussion, and then you make a conclusion about the accused vulnerability and dangerous situation. Do you feel qualified to do that?
What I've done, my lady, is I've listened to what Mr. Pistorius has told me. I then examined him to try and verify what he has said. And that is what the purpose of the examination findings are. And then to try and create a objective scenario, I've taken x-rays of the stumps so that one can visually see what is happening. And finally, I have demonstrated clinically the vulnerability and the instability of the stumps. So this is a process, my lady, where he has told me what he feels, and then I have tried to verify that for the purposes of giving the court evidence that is useful for the court, my lady.
You see, Doctor, that's not really an answer to the question. You see, what you do here is not you say he's vulnerable without his stumps, on his stumps. You say he is vulnerable in a dangerous situation. That was important for this report because it had to come back to court. Is that correct?
Yes.
Yes. So you feel qualified as an orthopedic surgeon to link his vulnerability to a dangerous situation. I say you cannot do that.
Milady, I have produced the medical examination findings, the x-ray findings, the clinical findings, and I have made a deduction, which is the same deduction that the court can make. And that was what the deduction I made from those findings.
You see, there you're right. You would give your expert views, the court will make the deductions. But you went further. But can I ask you, the same paragraph, that the accused on his stumps is seriously vulnerable in a dangerous situation with severely impaired ability to flee. So, it will be difficult. If you don't understand the question, then I'll go to more detail as far as the facts are concerned. But if you do, let's just get to an answer. Will it be possible for the accused to, instead of firing shots in the bathroom, run away?
Yes, it would be possible.
To run?
No, not run as you run or I run, but run as he runs. He is battling to walk. If you see how he's walking, he's battling to walk.
I hear what you're saying.
And for him to turn around is quite a process. I actually asked him to turn 180 degrees, and I counted 7 movements for him to do that. It is quite a process.
Yes.
And he has to put that stump down exactly in the right position. And he can't hit the grouting between the tiles.
Yes, I hear that. I'm going to show you, I'm going to point out certain things to you. And I hear what you're saying. Remember I said, would it be possible for him to turn around in that bathroom and run away?
And I said yes, but not as you or I run.
But he would be able to run, because he did. He ran.
I think that's
And he
fair.
never fell.
That's fair.
He was on tiles. He turned. He ran away. He ran to the room. He never fell.
Well, I never said that he falls every time.
You said, I will go through your report. You said he's battling to walk. You said throughout your report that he would often fall. It would be easy for him to fall. Do you know that he never fell this night on his stumps?
This night?
Of the incident.
I don't know that.
Let me just take you through it.
I haven't asked Canvas that.
Did you not ask him about what happened on the night of the incident at all?
Not at all.
Not at all. And he never gave you an explanation of what happened on the night?
No, milady, he did not.
Now, on this particular night, and I'm just in summary, broad strokes, Mr. Pistorius with a gun in hand, pointed forward, walked from his room to the bathroom. He never fell. That's possible to do.
Yes.
He then turned into the bathroom on the tiles, and he looked what was going on in the bathroom and observed certain things. That's possible.
Yes.
Because that happened. Yeah. Then he fired 4 shots with a 9mm pistol on his stumps.
Yes.
How would that affect him if he fires a shot on his stumps?
He would have severe difficulty depending on how he's firing. But yes, it's possible.
You said he will have severe difficulty. Yes, it's possible. He will have severe difficulty. Why?
Well, it depends how he's firing.
Okay, let's deal with it.
And
carry on.
And secondly, there would be a recoil problem from the firing.
So, what would the recoil problem be?
It could knock him off his stumps.
If I read your report,
depending on how he's standing.
Yeah. If I read your report, would that be probable that it would knock him over?
No, I really don't know. I don't know a 9mm weapon, and I don't know the amount of recoil. But I do know that if he is stretching out and he's having difficulty balancing, and the recoil would have an impact on him.
Especially, Doctor, I'm no expert, but if you have the 9mm pistol in both hands,
yes,
and your arms are stretched forward, and you aim at something and fire, that would even be more likely that the recoil would, on your version, on your understanding.
I think, just in fairness, my lady, I'm following the questions, but I think that what the statements do is maybe put the correct version as how he fired and what his body position was and whether or not he was leaning against something. Because it's unfair, it's that vacuum is there, it's created, and he keeps the vacuum open.
With the utmost respect, my lady, there's an objection to where I'm going. I will get there. If I don't get there, my lady, Mr. Roo will have an opportunity to re-examine. The questions I've put, my lady, is something different. It's not about what happened that night. I will get there. I don't understand the objection. I've not put a question that I'm not allowed to. My lady, I will get to...
You will get to what the accused gave evidence about, the exact words.
Yeah, and if I don't...
And the exact position.
Yeah, and if I don't, then Mr. Roo will do it in cross-examination. It's not a question that Mr. Roo can object to. I beg leave to carry on, my lady.
Mr. Roo?
It is correct, but not on one point. And that is the difficulty created. He's dealing with the accused version. And he's dealing with the version holding the gun with two hands. But that's not the full version. So that's misleading to that extent. And if he says to him, I put this to you, but that's not the full version, I will later explain his full body position, then he can go on and fragment it and break it up into pieces. But it creates the impression by his questions that's what it was. He's standing, and how can it be? He's standing, holding the gun outstretched with two hands. That's the impression it's created, is the version, which it's not.
My lady, with the utmost respect, I've never said it's the version.
I will give you an opportunity to get to where you want to get to.
Thank you, my lady.
Thank you.
Now, Doctor, if, that's how I asked the question. I didn't say that's the accused version. I said, if the accused held the gun in both arms, stretched forward, the recoil will have an even greater effect than with one hand. Am I right?
Well, with his hands together, he'll have less chance of balancing. Yes, correct.
Now, except if the accused foresaw that the recoil may be a problem and deliberately stood with his back against the wall to be able to fire better. That would assist him, am I right? If he stood with his back against the wall.
If he was leaning against something, it would have a big beneficial effect on his ability to balance. Yes.
Yeah. And so that would be a conscious decision to balance himself. Otherwise, the gun would knock him over.
I don't know, but I mean, the fact is that if he's leaning against something, he is definitely in a better position from a balancing point of view.
Good. Now, Doctor, we're still busy with his version on the night. He then turned around, and from that bathroom.
So you're not going to deal with his version at all?
His version is he stood with his back against the wall. I did.
His version was he stood with his back against the wall?
Yes, my lady. That's what I put to the version. Okay. He balanced against the back, the furthest wall, and that's what I put to the version.
But you see, I think Mr. Roo objected to the fact that it's not exactly how he described the way he shot at the door, unless I misunderstood him.
I think Mr. Roo indicated to me that he thinks that I did it, my lady, but
But later he's made a concession. He says that's the version that he's put his back against the wall, so that resolves that.
That covers it. Thank you.
Thank you, lady.
Thank you very much.
Then, Doctor, I just want to get there. The accused then walked back to the room on his stumps. In the room, he searched. There were at least fans standing in the room. He missed them all. He never fell. He searched the room. He even searched behind the curtains on his stumps. He never fell. He was able to do that. It must then be possible. Am I right?
Yes.
Okay. It happened. He then, with the firearm in front of him, in any case, he held the firearm in his hand, firearm in front of him. He walked back to the bathroom. My lady, perhaps it would be easier if later we want to follow it in the record is page 1476, my lady.
Thank you.
In the bed, in the bathroom, on the tiles, with the grout and everything. He walked to the door and tried to open the door. So that is possible for him to do all that.
Yes.
He tried to rip open the door. I ran back to the room. That's possible because it happened.
Yes.
He did not only ran back to the room, he ran back to the room, he opened the curtains on his stump. So that's possible for him to do.
Yes.
He opened the doors on his stumps. That's possible to do.
Yes.
Let me just, I'll carry on from here. But he was able to move two fans on his version. Whilst the fans were on, he was able to pick them up, the one fan, walk to the front of the bed and put it down on his stumps.
He must just, in all fairness, go to the correct version of the accused, what he was doing with his other hand. That is page 1469 and 1523. Not as put by Mr. Nell.
Well, he's not done yet.
Yes, but he put a sentence that he was walking with the fan in his one hand, and that's not the evidence. He was doing something else with the other hand, my lady.
But my lady, yes, the objection is not an objection. The accused version is a version. The objective version is also a version. My question is based on an objective version. Objective version is we know where the fan was. We know where he put it down. All I'm asking this witness is, was he able to do that?
Yes, but I think Mr. Rui is quite correct. If you're going that way, you ought to say, with his one hand, this is what he was doing. With the other hand, this is what he was doing.
My lady, with the utmost respect, I will make it clear, I'm not going to his version.
You're not going to his version?
I'm doing an objective version. I'm doing a fan moved.
Okay.
So.
Yes, Mr. Rui, you want to say something?
My lady, I will listen. If necessary, I will object again.
Thank you.
As long as you're not saying that's his version the way he described to Dr. Fasswell.
Thank you. Yes, Mr. Nell.
You see, with the utmost respect, I think Mr. Rui assisted me. I'm going to do both. I'm going to do both. The accused said the following on page 1469.
Which I don't have.
Yeah, just for the court, it's not a big thing. If you don't follow, I'll assist you as far as I can. I got to the fans where the fans were. I took the small fan, the floor fan, I placed it pretty much just inside the room. So if on his stumps, there's little small fan, is able to take the fan and put it inside the room. It's possible for him to do on his stumps.
Yes.
Good. I took the bigger tripod fan and I took it by the part just underneath the fan and I placed it in the bedroom. If he used one hand or two hands, but he was able on his stumps to take a fan, a tripod fan, and put it inside the room.
Yes.
But, you know, objectively, he moved that fan from the door to the front of the bed. So that must be, and we have the photographs, but let's give him the benefit of all the doubt. He was able to pick it up and move it 3 meters.
A fan like that, providing he's using it, well, it doesn't really matter if it's one or two hands. You don't necessarily need to carry the fan 3 meters. That can, in fact, be your tripod gate. That could be a walking aid, in fact.
Okay, that's possible. Yeah, let us see. Okay. So he would be, that would, so the way you explain it, you would take the fan, move it a couple of centimeters, put it down, move it a couple of centimeters, put it down. So that's possible.
What I'm saying is that it can be a balancing aid. If he felt himself falling over, he could put that down to balance himself, to prevent himself falling on the floor.
I see. We'll get back to that. I just want to make sure you get the photo album. But let's carry on. We were busy at with his version 1476. Remember I said to you that he ran from the bathroom he opened the curtains and he went onto the balcony. On his stumps, he's able to do that. To walk from the bathroom tiles, carpet, onto the balcony with whichever's on the balcony. Am I right?
I don't know if you're right, but that would be possible.
Yes. So nothing in your report would say that that's impossible to do?
Nothing.
Okay, good. Then, so on the version that I gave you, and on your clinical findings and whatever you've seen, it's all possible. Am I right?
I don't know what all possible means.
Everything I told you that he said happened. How he moved from a bathroom.
A blanket thing like that is unacceptable.
You see, doctor, you see, why would you say it? Why would you now say that? Do you feel that you, as the treating physician of the accused, that you are objective?
I feel that the evidence that I've produced for court is objective, yes.
Now, why would you then not just follow my questions? Everything that I told you today, you said it's possible, can happen. It did.
A blanket statement, like everything I've said, I mean, that is certainly a strange and an unacceptable question.
Indeed. I'll do it differently. I'll do it.
So if we go item by item, which we've done, that's fine.
Now, and the most amazing part of this is walking to the bathroom on an accused version, firing the shots, running back from the bathroom, all done in the dark.
I have no idea what the lighting condition was.
On his version, it was done in the dark. So it's possible for the accused to do all that in the dark.
You must remember that in the dark, it depends on how dark it was. And if you've got visual sight of something, then you can reference it. If he was totally in the dark, he would have had to be holding on to things, otherwise he would have fallen down.
You see, Doctor, that answer of yours assists the state. His version is, it was pitch dark. Pitch dark. So that would then not be possible. He should have held on to something.
My lady, with respect, if you say his version is that it was pitch dark, it's this overwhelming statement. It's when. Because we have different stages what he was doing with his hands when it was pitch dark in the bedroom, and different stages later when he focused on, I don't want to give the answers, but you can't say it as one statement that his version was pitch dark. We have certain stages in what he was doing.
Yes,
Doctor,
Mr.
I'll do that. When the accused walked from the room to the bathroom, it was pitch dark. Pitch dark. He never fell. That's possible? Or not?
If that's what happened, it's possible.
You see, that is a strange answer. I'm not saying that happened. I'm saying that's what the accused said. And I'm asking you if that's possible. I'm not saying that happened. It's not the state's case. It's the accused case. Would you think it's possible for the accused to walk in a pitch dark room on your clinical findings without falling?
I would find it improbable, and yes. I would suggest that he would have to hold on to something along the way to do that.
For once, I agree with you. I agree with you that if it was pitch dark, it would have been improbable. But it goes further. The accused is able to, in the pitch dark, on his stumps, pick up a denim from the floor.
Sorry, what was that?
He picked up a denim, trousers from the floor. In the pitch dark, on his stumps, never fell over.
But just 1 minute. 1 minute. When he picked that denim up, wasn't he able to see there's a denim because there was a light, a red light?
There's a blue light.
Oh, blue light,
yeah.
Yes.
My lady, the state's case is something different. I'm testing the accused version. On his version, that provided no illumination. He could see very slightly the denim, but I've been through his evidence in the break, my lady, very limited illumination. So that is the facts, my lady.
But that's the difficulty, my lady. That's not put to the witness that when he picked up the denim, he had limited visibility. It's put that it was pitch dark, and it's inconsistent with the evidence in the LED light. But it's not put to the witness, and that's my problem every time. He says it was pitch dark when he picked it up. When he responded to you, he tells you that it was limited light. It cannot be both correct. The second one is correct.
But will the court grant me a moment? I just want to get my hand on something in the record. But I just want to get my hands on a piece of the record. I want to refer to 1805. May I just reach for that computer, my lady?
Yes, yes, yes.
I'm better with the hard copy, my lady. May I just add back this? Page 1805 of the record, my lady. From line 20. Now let us deal with the blue light. The only bit of light in the pitch dark room was a blue light. That's correct, my lady. In the on-off switch of the amplifier. That's correct, my lady. Nothing else. There's a tiny tiny blue light on the light switch, but it does not, it barely eliminates any light. So that is the facts. That was what was said.
So I'm sorry, that must have been my assumption, how he saw the...
Yes. That's his version, my lady. But, Doctor, let's carry on. Let's forget about that.
My lady, I may say this. That must be read. There are other places where he deals with the silhouette at 1734.
What's that?
1734.
Hold on. Can we just, we will not finish the way we're carrying on. Can we just, if he leaves out something, there will be re-examination.
I agree, my lady. My difficulty was with questions like putting it was pitch dark when that's not the evidence. So I try not to be a jack-in-the-box and object all the time. But some of them are just wrong.
Please, good. I'll carry on, my lady. With the leave of the court.
Yes, please, carry on.
Now, Doctor, at least we have the following. Now, from that little small blue tiny light, he walked to his bed, next to his bed. There he fetched his gun. Now there it was pitch dark, even Mr. Roo will agree, on the accused version. So that's improbable that we're able to walk there, not fall in the pitch dark.
Well, you would need either to be holding on to something, or you don't need a lot of light. If you can see the denim, then you've got more than enough light to visualize where your position in space is.
And I have that. But let us just for argument's sake, it's got nothing to do with his version. I will use it in argument for the state's version. So I'm not saying the accused said that. If it's pitch dark in that room, it will be improbable for the accused to walk without falling.
Without holding on to something.
Yeah,
yes.
It would even be less if he is walking in a pitch dark room with his one arm stretched out in front of him, in a pitch dark room, without falling over. He will have to hold on to this.
Yes.
Now, are you saying then that with reference to page 3 of your report, where you spoke about that the accused said he struggled in the dark, the struggling in the dark would only be that, or you'd be able to overcome it by holding on to something in the dark. That would then be all right.
If he has some sort of visual reference, or if he's holding on to something, he would be able to balance.
Can I ask you, based on your version, and I'm not accepting, I'm just saying, running back from the bathroom in the pitch dark, would you expect the accused to fall? If it's pitch dark, he's running, he can't really concentrate on how to put his thumbs down or things, on your version.
It would be difficult.
What would be difficult?
To run in the pitch dark, holding onto her weapon. And you would be at high risk for falling.
And in all probability, he would fall. If you just look at the probabilities, from where you're standing.
He would have a high risk of falling, yes.
But if there were light on, the risk of falling would be less, if you could see.
Correct.
Okay. Now, you see, interesting point you made in your report is you said the accused would have a severely impaired ability to ward off danger without a weapon.
Yes.
Why did you put that in there?
Well, this, as I understand it, this court case is about a weapon. And if I say to you that he has a severe impairment to defend himself, that is true. I mean, a really severe impairment to defend himself. But obviously it changes if he's got a weapon.
Can you just stop a little bit? I think we have a problem with the machine. How long ago did it stop working?
Previous question is on the machine. This question.
This question is not on the machine. Okay, what do you think is wrong with it?
I don't know.
What you going to do?
Just freeze.
Okay. Okay, how long do you think it will take? Okay. We have a slight challenge. We have to stop and allow the machine to come back to life.
Indeed, my lady.
So we're going to take our tea a little early. I think it's, what time is it? 10 past.
It's 11:05, my lady, yes.
Yes, we're going to take our tea now, come back at 11:30.
Would the court rather wait till we call the court? We won't call before 11:30, but if they're not ready,
thank you.
So may I ask that the court would remain in chambers and then we'll call.
We'll do that. Okay, thank you. Court will adjourn.
I'm gonna call now. Yes, the other man feel the pause. No, don't worry about it. I think maybe I'll have to spot.
Hello? Hello? How's it? Hello? Sure? Oh, come. Yay! You are the bee's knees and more. She needs a mic, guys. Yo.
Let's drop the microphones. Then we'll be on this side.
Joburg, good morning.
He's wet, eh?
Yeah, mom. Okay, cool. It's Iveka and Karen, eh?
So it's backfired on them. Sort of. Doesn't really.
I mean, they want to look at the psychologist report, but I don't think it's backfired.
Feedback?
Yeah, feedback. I mean, obvious first prize would have been diminished capacity. I mean, they've sort of reserved their rights, but.
Can you tell? You don't have prompts. So you have to talk to Iveka.
Oh, it's nice and toasty here now.
Yeah,
Who are you sitting with in there? Who is that? Should I just like sit on the belt? Just sit on the rail. Okay. Who's that guy you're sitting with?
Rohit Kashri from ITN. How's my makeup?
You're a bit, you need to go and clean up your clean under here. Your mascara has done things.
Cool.
Anyway.
You could fix it. You're a mommy.
You can use my spit.
Use your spit.
No, but you've got it. What have you been doing? You were like just pasting your eyes.
No, it's because I was so tired and now.
Okay. Open.
How much
Yes.
You happy?
Do it for now. Close.
Can you take a what?
What? Oh.
Check my makeup. Apparently it's fucked.
No, it's not, well, you look like a heroin addict.
I am a heroin addict. Why does he bring that up now?
Sorry. What did Oscar always say? Did he say that he was on his stumps, or did he say he was on his prosthetics when he shot?
It's accepted by the state and the state's experts that he was on his stumps. He's always said that he was on his stumps, but he says he was on.
Something on your lip? Something white.
Sorry, I can't hear you.
What's this?
Fluff.
Oh.
So it's accepted by the state that he was on his stumps.
Yeah, but they're saying that he was also on his stumps when he hit the cricket.
Know more. eNCA.com.
I think this day is going to go down in history for the equality of disabled people. I think it's such a significant day in sports.
For years, Oscar Pistorius was South Africa's golden boy, championing the rights of disabled athletes and winning. And making history competing against able-bodied runners in the 2012 London Olympic Games. He may have lost that race, but he won a bigger battle to compete in those games at all. And he was a man used to winning. Man or beast, he took them on and won. Until he didn't. It was at the Paralympic Games in 2012 where Pistorius allowed his anger to take over. He had lost the 200-meter final. He complained that his opponent won because he had longer blades. This was perhaps the first glimpse of a different side of Oscar Pistorius. Angry, petulant, unreasonable. Now that he's standing trial for the murder of his girlfriend, Reeva Steenkamp, the prosecution has latched onto what appears to be his darker side.
Ready?
And the fact that he loved fast cars and he loved his guns has taken on a sinister tone.
It's a lot softer than brain, but it's like a zombie stopper.
The prosecution has attempted to paint him as a jealous, self-centered and easily angered boyfriend.
Don't do this, do that. You don't want to hear stuff, cut me off. Your endorsements, and this is important. What I'm saying, she's saying, your endorsements, your reputation, your impression of something innocent blown out of proportion and f***ed up a special day. Everything that was important to you, everything that's important to you, messed up her day.
Sports psychologist Dr. Ken Jennings says the world of high-performance professional sport has been known to breed selfishness.
So the boundary between what the needs of another person are versus what I want often gets blurred, because the top athlete invariably always gets what he wants, and he drives at that. I mean, that's the sporting drive, and sometimes that starts also working in interpersonal relationships.
When Pistorius took the stand, the image of the confident sportsman crumbled.
I would like to take this opportunity to apologise to Mrs. and Mr. Steenkamp, to Reeva's family, to those of you who knew her earlier today.
During his testimony, Pistorius gave insight into his career. Despite the glory, it was often a lonely life. And although campaigning confidently for the rights of the disabled, Pistorius admitted that at times he was ashamed of his prosthetic legs.
I don't know if it's maybe just I get shy about them or embarrassed about them when I don't have them on. When they're part of me, it's different.
Perhaps the most startling contrast to his fearless sportsman persona was the revelation that Pistorius could be suffering from an anxiety disorder.
It is my opinion, my lady, that Mr. Pistorius has an anxiety disorder. Individuals with an anxiety disorder work hard to control their environment and be very prepared in order to alleviate their levels of anxiety.
I think Oscar the sportsman and Oscar the person may be two different things. So what an athlete does, he has to fill a sporting persona as such. And so in your competitive environment, your top athlete really cannot acknowledge any frailties, vulnerabilities. So it's what I call the top sportsman often has to walk around with a mask of competency. And the mask of competency basically says, I'm confident, I can win, I'm dominant, and I'm in charge. So, and it's a sense of a bravado on one level, but this is the nature of competitive sport.
It may be that Oscar, the conquering sportsman, Oscar, the selfish boyfriend, and Oscar, the anxious man, are all part of the same flawed person. Ultimately, it will be up to Judge Thokozile Masipa to decide which Oscar Pistorius pulled the trigger on the night Reeva Steenkamp was shot, and whether it was done intentionally. Diane Hawker, Johannesburg.
Know more. eNCA.com.
Thank you, Mr. Mr. Nell.
May it please the court, my lady. We lost one question only.
Oh, okay.
Two
questions.
Two questions. The one is where I put to Dr. Versfeld, if the accused can see, if there's light, the risk of falling is less.
Okay. All right. Doctor, you still under oath? You are still under oath?
Yes.
Yes, thank you very much.
Yes. If there's light, the risk is less.
Then I asked you, just before we stopped, why did you say that the accused will be severely impaired, the accused has a severely impaired ability to ward off danger without a weapon? And the question is, why did you mention without a weapon?
Because, in fact, this is a trial about using a weapon.
So, in fact, what we have then to take into account is you try to ensure that your report is relevant to the trial.
I did try to make it relevant to the trial. The question of a weapon, if you make that statement under the circumstances, I didn't think it made sense. If you made the statement without putting in the weapon, then I didn't think it made sense.
So would the flip side be true that if he had a weapon, his ability to ward off danger would not have been severely impaired?
He is still impaired, but it would not have been as impaired as if he didn't have a weapon.
You see, Doctor, and unfortunately, I'll have to put scenarios to you because we're still busy with the trial and the court's made no findings of fact. Now, you would agree, having observed what you did, having made the clinical finding that you did, if it was dark, that would have affected it. It would be more probable that the kids would be unable to walk or run without holding onto something and falling. You agree to that, am I right?
Yes.
And also, if there were things in his way, like, let's use a duvet. If it's dark and he's on his prosthesis and the levels would differ, that would also cause a fall.
That would also be a problem, yes.
And things like electric cords would also be a problem for the accused to walk over.
If he stood on an electric cord, that would be a problem.
The information you put in your report in the first couple of pages, let me just say that's from page 2 to page 7, line 1, those you got from the accused?
Yes.
In what format? Did he come there with a document?
No.
You asked questions?
I asked him, what is he like on his stumps? And I asked individual questions, yes.
And in asking these questions, you had the trial in mind?
In asking the questions, I had in mind to try and establish the disability that he had. on his stumps. And obviously that information was for the court, yes.
For the court?
Yes.
The last issue I just want to canvass with you, Doctor, is based on your interview and your clinical understanding, it would be unlikely, highly unlikely, that the accused would be able to walk in an area where there are extender cords, fans standing, devise, an iPod, a head shaver in the pitch of night and not fall over or bump against it.
If it was indeed pitch dark, that is so.
Good. Thank you, my lady. I've nothing further.
Thank you very much. Yes, Mr. Roux?
Thank you, my lady. Let's... Doctor, can I move closer to the context of the case? You were asked a number of questions, and I'm going to do this now with page references to assist the court. And the one is that the evidence was there was a slight illumination so that he could see the jeans, the denims. My lady, for the court's benefit, it would be pages 1734 and 1807. So it's not that it's pitch dark to stumble over.
It's 1734.
I'm sorry, my lady, 1734, and also relevant to that is page 1807.
Thank you.
So it's not that it's pitch dark, and it would stumble over the jeans, the denims.
Well, the moment there is light available, he will be able to use his vision to balance, to help him balance.
The second part that I try to stick to chronology is, on his evidence was that he went to the side of his bed to fetch his gun, and he explained that he was doing so by touching with his one hand on the floor for balance purposes. Would that make sense to you? That is page 1471, my lady.
Yes, my lady. That would make sense.
Would that be consistent with your findings?
Yes, my lady.
Now, we're not talking about Mr. Pistorius running around the track. We're talking about short distances. From the bed to the entrance of the passage is about 2 to 3 meters. And there was light coming from the bathroom, so there was some illumination in the passage. And he's focusing now on the passage in moving there, my lady. That would be pages 1774 and 1832. Now, you were talking about a focal point or some sort of visual reference.
Yes.
So what I'm putting to you, it's not that he's walking in the dark. He's got a focal point. He can see light ahead of him in the passage.
Yes, my lady, not only that, but if he's walking in a passage, my observations were that he would have been touching the walls as he goes along, because he's not sure on his feet. So there would have been some form of touch as well as the light, if it is something that he can touch onto.
Well, I'm getting to the first point that I make. The path from the bed to the passage, that's about 2 to 3 meters only. And there is a vision point, a focal point. But now I'm going to the passage. It's about, the width is about 1 meter, maybe a little bit more. But this was in fact this evidence that he used his hand to balance himself against the cupboards. That would be page 1837, my lady. And 1771. Would that make sense to you?
Yes, my
So
lady.
it's not this man walking in the dark, in the pitch dark. It's also not an outstretched hand as demonstrated to you. The firearm was in front of him and the elbow close to the body. Would that make sense? And the other hand was, of course, then finding some assistance against the cupboards.
Yes, that would make more sense than an outstretched hand, my lady.
And lady, just, if you will allow me, I'll give you the page reference for the elbow. It's 1831, my lady.
Thank you.
And we've dealt now with leaning, when the shots came about. I'm not going back to that. He moved backwards, and again his evidence was balancing with his one hand against the cupboard. Would that make sense?
Yes, my lady.
Now going into the bedroom, that's dark, but we talk about a distance of 2 to 3 meters of a person knowing where his bed is. What would that do? Would you want him to fall? Would you think he would fall?
Well, if he knows where the objects are, that would help protect him from falling. Yes.
And we've dealt with the fans, and I'm not going to deal with the evidence holding on to the bed and so on. What I need to know is this. And in all fairness, maybe a difficult with Mr. Nell's questions, I saw when you demonstrated that he was not looking at the legs at all, what you demonstrated. So I sort of understand it, but if you look at the pain factor, what is it if you're in that state of mind? Is it something like adrenaline or any other substance that the body would excrete? And what would that do, if at all?
We all know, my lady, that if you are in a dangerous situation, or in a situation where you are fearing, that allows you to do maybe a little bit more than you normally can. That is so.
Then it was put to you, well, if there's an iPod and a head shaver and a number of objects that you would expect him to trip over it or fall over it. That's, of course, if he came in contact with them.
Absolutely.
Would he necessarily fall when he walks over the duvet? Right next to the bed?
If he put the foot down on a thing that he wasn't expecting, he would be in danger of falling.
Yeah, I understand danger of falling, but would he fall as a fact?
No, not necessarily.
Yes. And would it make a difference if the bed's right next to him?
My lady, if you watch him walking, he is looking for places to put his hands so that he can balance himself. So if he knows that he's got an object nearby, that would allow him a little bit more freedom, because then he could either touch and balance on that, or if he fell on that, that wouldn't be the same as crashing onto the floor.
Now, you said right at the beginning of cross-examination, when reference was made to Mr. Pistorius' version of running, have you asked him to demonstrate to you over the time what he would consider as running?
I haven't witnessed Mr. Pistorius running. I've witnessed him walking.
On the stumps, what would you say? What could that running be? You said it's not running as Mr. Nell would.
No, I mean, it would be a number of very short steps, and it would be quite cumbersome. I mean, my lady, when he puts his leg down on the left side, the stump has to be in a specific position. And he actually goes down on the left side each time he takes a step, because the knee is bent and it is turned inwards, and you can actually see the leg buckling a little bit when he puts weight onto it. So it wouldn't be running as you and I know it, my lady.
Thank you, my lady. I have no further questions.
Thank you very much. Doctor, thank you very much for your assistance. You may be excused.
Thank you, my lady.
Yes, Mr.
May I just seek an indulgence of only 5 minutes, my lady. The next witness available, I just want to get the reports ready.
We'll take a break.
And you see four.
Yes, Mr.
My lady, before I call the next witness, there are four things I need to do. One will stand over, that's in relation to a photograph that Mr. Nell just needs to check whether that can go by agreement. And then there would be three other matters. The one would deal with the electrical cord, I'll come back to that. The second will deal with the report, the guard track report that on page 431 we said we would hand it up, but somehow it was never handed up.
What report is this again?
The guard track, you remember when Mr. Peter Barber
and Mr. Stander handed the key over to the defence team. The police did not make an inventory of everything they left in the house. That never happened.
Yes,
Similarly, I wish I didn't have to try and explain it. But I'm in an enviable position that I just cannot. And I don't have it.
Well, I'm not happy, but at the same time, I don't know how I could order the state to produce something that they say is lost. But how it was lost, that is my concern. How? How did it get lost?
It's a concern, my lady. If and I say it with the utmost respect, I cannot blame anybody to be concerned about that. But the reality is, my lady, that I'm standing next to the investigating officer. And I don't have it. Well, my lady, let me rather say, it wasn't handed in or seized, formally seized on the scene in terms of inventory and handed in into the police's exhibit facility.
But did someone look for it since the correspondence happened? Did someone try to look for it?
Milady, in terms of look for it, that would mean at the police station, an exhibit store, and those kind of things. Because
if you say everything that was seized was in the inventory, and it's not in the inventory, I wouldn't expect the police to search for it at the police station.
Wouldn't? I perhaps didn't hear correctly. You would expect the police to go search for it?
I wouldn't expect them to search for it at the police station.
Yeah.
Since according to the inventory, they didn't take it.
Yes. So.
But since the request was made by the defense, did someone try to find it?
Well, what happened, milady, is that at page in the document that the court has.
I can't read most of it. It's just impossible.
Yes, my lady. Second page, I cannot read, lady, but may we count the pages? Page 1, 2, 3, 4 is a photograph, my lady.
Yes.
5 is a photograph. Then on the next page, my lady, there's a response by the investigating officer at the bottom of the page where it's indicated by Captain van Aert. I again checked all relevant entries pertaining to exhibits seized. I also consulted with Warrant Officer van Staden about the seizure of exhibit. The extension court is not in the possession of the SAPS, nor was it seized from the scene. And that was, the defense was informed of that on the 9th of June.
That means no one tried to look for it because the police did not seize it.
Well, my lady, to try and look for it, I say with the utmost respect, my lady, we looked for it in our records. Mm-hmm. We looked for it by consulting the person that seized all the exhibits, that's Van Staden. My lady, we will gladly look if the court if the court instructs or indicates that the court would want us to look somewhere, my lady, we will go look. But as I'm standing here, my lady, I cannot think of somewhere to go look.
And it's not possible to go to the house anymore and look for it there.
Indeed, my lady. I think it was sold. The accused took that house over 3 days after the scene, so it would serve no purpose to go back there, my lady. So, my lady, I just don't know where to look if the court would ask me if I looked.
Yeah. All right, anything else?
No, my lady, that's the only way of responding to this.
Yes. Yes, Mr. Roux.
My lady, I understand the difficulty, but I think it's a bit too easy. And if I may say, it's not at the house. That's the first source that we try to find it.
It's not at the house.
It's not at the house.
Yes.
And the fact is, these are the cold facts. The police took possession of the house. The keys were only given the 18th and 19th February, later on, when we were given access. We talk about the 14th and the 15th. The police sealed the house. The court was there. The next photo, the court's not there at the place where it was. It's gone.
When did, excuse me, when was the first time when it was realized that the extension was missing?
We saw on the photo, because we saw a number of changes on the photo that we referred to previously, and we saw on the photo there's no court. But of course, in cross-examination, the relevance of the court became apparent. That's when it became relevant. Not before. You see a court that's not there and you assume that the police had removed it as part of the exhibits. But the relevance came whether that court could extend or not extend. And that's why we gave them the length of that court, because that's absolutely relevant. And what I would have thought the state should do is at least, and I know you can't order them to give them if they tell you they don't have it, but at least order them to investigate it, to say who was in control of the house, who's the person that controlled the house, that sealed the house. What does he say? Why was the court there on the 14th and why is it not there on the 15th whilst the police was in possession? I think at the very least we're entitled to an explanation. And that the court can do. And if it's then a cul-de-sac, then it's a cul-de-sac with its consequences on the evidence. But if it's not, at least the court is there and can assist us. So an alternative, that's what we would ask in view of the response by Mr. Nell, that you order them at least to provide you with an affidavit by the person responsible or the person that is in control of the house to explain that. Because we have the photos to show you. One day it's there, next day it's not there. They at the house. They had detention of the house. Thank you, Marlene.
Yes, yes, Mr. Nell?
Lady.
Yes, what are you saying to the suggestion by Mr. Roo? Isn't that a fair request?
For the state to investigate it now.
Yes.
May I have a moment? If I understand it correctly, Mr. Roo would want the court to order that we provided an explanation by the person that sealed the house.
Well, person or persons.
That sealed the house to say that, well, to explain if they know anything about the court. Because there's lots of things in the house, Malene.
I know that.
So,
but this one happens to be relevant.
For now, yes, my lady. The issue is just, we'll do that, but I just don't see how that would assist, because it's as asking a person if...
Well, it would definitely assist. It may not assist Mr. Roo, but it would definitely assist me, because I'm very unhappy about this.
Yes, my lady.
Yes.
We've taken steps. If we have to take the step one further to find out from the person that sealed the house if he can shed any light on it. My lady, when I first learned of it, my first impression is if it's not on the inventory, it was left in the house. Now, that might be a possibility. But if we file an affidavit from a person in charge who said, I sealed and I was...
Do we know who that person is?
Yes, my lady, we know. It was Colonel van Rensburg and Warrant Officer van Staden. The evidence was late. Colonel van Rensburg said that he was remained at the scene up until the time that they sealed it. My lady, we'll do that if it assists the court. But, my lady, I just think that we're talking about lots of things that happened.
Well, it doesn't assist to go on and on about that.
Yeah, no, it's fine.
Because I think it's very important that we should know what happened
if that's what the court orders.
Because what we have so far is that the house was locked.
And
there was no burglary during that time?
And we would say it was still there. It's not at a specific spot,
Yes,
but
yes.
yeah.
Yes, I ordered that that person, whoever he is, who was in charge of the house, on the 15th, is it the 14th and the 15th of February? Is it the 14th and the 15th? Those are the dates. Are those the relevant dates?
Those are the two relevant, 14 and 15.
14th and 15th of February. Deposed to an affidavit to explain exactly what happened during those days while the house was under his control. Yes.
It'll happen, Malady.
Yes. Thank you.
I'm indebted to thank you, my lady. Just sent for housekeeping the report by Dixon that we said we would hand it in. It's JJJ3. We gave it to the state at the time and said it would not be handed in. It was just an oversight. And then, my lady, the guard track, I said that I referred to at page 431, that it would be handed up, but somehow there was an oversight. It was never handed up. I've marked that, with your leave, my lady, as Exhibit TTT, the guard track of the Silverwoods estate.
Thank you very much. Yes,
Then call the next witness, my lady. It's Ivan Lynn.
Yes. Did you not mention something else? Dixon report?
No, my lady, what happened, I made reference to a photo of the ambulance, but Mr. Nell requested me that we stand that over. He just wanted to check on it and then come back to me tomorrow.
Thank you.
My lady, similarly for this witness, we asked the order to stand in regard to media recording.
The image of this witness is not to be published in any form that includes filming. Thank you. Yes, the witness may be sworn in, please.
Sir, please state your full names for the record.
My name is Ivan Lynn.
Do you have any objection in taking the prescribed oath?
No.
Do you consider the prescribed oath to be binding on your conscience?
Yes.
So do you swear that the evidence about to give shall be the truth, the whole truth, and nothing but the truth? If so, raise your right hand and say, swear help me God.
So help me God.
Witness is sworn in, my lady.
Thank you very much. I don't think I got your name correctly.
What's the name
Can
again?
you spell it for me, please?
I-V-A-N.
Yes.
My surname is Lin, L-I-N.
L-A-N?
L-I-N, my lady.
L-I-N.
Oh, thank you very much, yes. Lynn, that's how you pronounce it?
Yes.
Thank you very much. Mr. Lynn, you may be seated if you so wish.
Thank you.
Yes.
Thank you, my lady. Mr. Lynn, before I start with your evidence, you have compiled a report relevant to your evidence in this matter.
Yes.
Would you care to look at a document and identify it to be indeed your report? You have a copy with you?
I have a copy of my report, yes.
My lady, ask the court to accept it as Exhibit UUU.
Thank you.
Now, Mr. Lynn, going to your report, more to the back, the last annexure to your report is in fact your curriculum vitae.
That's right.
Do you confirm the correctness of that?
I confirm that.
Now, can you tell the court what are your qualifications?
My qualification is electrical engineer. I've been practicing as a acoustic engineer since 1992.
Where did you study and where did you qualify?
University of Witwatersrand.
When was that?
1992.
And after qualifying as an electrical engineer, what was your career path then?
I joined a partnership of a company involved in acoustic consultation and the design of broadcasting facilities. And I've been a partner of the company ever since. And the company there's been different form of company up to now, but still the same group of partners I've been involved with.
What is the company's name?
The present name is called Pro Acoustic Consulting Engineers.
And what was the previous name?
Pro Acoustic Consortium.
Consulting. And are you a director of Pro Acoustic?
That's correct.
And tell me, in your profession as at Pro Acoustics, what is it that you do relevant to acoustics and to sound?
We study and research the phenomenon of acoustics and how humans perceive sound and the transmission of sound and recording of sound thereof. My lady.
Now, let's go to your report, Mr. Lind, and we can deal with the questions that were posed to you. Do you have the report in front of you?
Yes, I do.
Can you start with that?
Yes. Sorry, I didn't understand.
Can you just tell the court what the question was there, right in the beginning?
The question posed, can one reliably differentiate between a male and female scream at about 80 and 177 meters away, respectively? Can one reliably discern emotion of a scream from about 80 and 177 meters away, respectively?
And then do you deal with the two questions in your report?
That's correct.
You deal also with certain definitions?
That's correct, my lady.
In order to assist the court in understanding the acoustics relevant to this?
That's correct.
Can we go to the definitions? I see the first one's an acoustic engineer. What is an acoustic engineer in general terms?
An acoustic engineer examines the science of sound creation, the environment for the sound creation, the behavior of sound transmission from sound source to the sound receiver. For example, sound amplification, sound attenuation, and the perception of sounds. And I put it in the brackets, psychoacoustics.
Is that the perception of sound?
That's correct.
We'll come to that. And ambient noise level?
The background noise level measured at a specific location at a specific time. Due to the dynamic nature of sound, it is frequently measured over a period of time to obtain an average value. It is expressed in decibels and with a relevant weighting curve, such as A or C weighting applied.
And you also make reference to the word audible or audibility later in your report.
Yes.
If you refer to audible or audibility, in what context do you refer to that?
When sound is loud enough to be heard, audibility of a sound is dependent on the background ambient noise level. Typically, a sound should be 10 dB above the average ambient background noise, or 5 dB above the maximum background ambient noise level to be clearly heard. The perception of audibility may vary from person to person, depending on the hearing sensitivity of each individual.
And dBA?
A measurement of sound spectrum with A weighting curve applied is expressed as dBA. A weighting is applied to instrument measure sound levels to account for the relative loudness perceived by the human ear, as the ear is less sensitive at low audio frequencies.
And decibels?
The decibel is a logarithmic unit used to express the ratio between two values of physical quantities, often power or intensity. Within the context of this document, decibel is used to describe the level of sound pressure variation.
And frequency?
The number of alternating cycles per given time unit. In this context, it is used to describe the pitch of a sound and expressed in hertz.
You can carry on.
Hertz, a unit of frequency in cycle per second. Shall I proceed to intelligibility?
Yes,
Is that how you like? Okay. Describe the degree of...
Is that intelligibility?
Intelligibility. Describe the degree a sound can be understood. Not it is a process that involves human interpretation. Next item, mid-frequencies. Typically, the frequency range from 500 Hz to 2000 Hz. Psychoacoustic, the science of sound perception. Next item, sound attenuation. The reduction of sound energy through a transmission medium or a barrier. Next item, sound spectrum. A sound spectrum is a way to describe a sound signal in the frequency domain. A sound signal is composed of varying mix of different frequency components, each with its own amplitude.
Then you have the next paragraph to say that the views that you're going to express later in your report must be considered with due regard to some factors.
That's correct.
Are you going to deal with those factors?
Yes.
The court should consider.
Shall I read through? Okay. Number one, hearing is a passive physiological process where audible information is received by human ears. Next item, listening is an active process where the information received by the human ears is interpreted and deciphered by the brain. Next item, 5.3. As the act of listening involves a process of referencing to information available to a specific listener, the actual perception of sound through the listening process may vary from one person to another, as each person may have different bases of information references due to factors such as individual cultural background, languages spoken, and upbringing. Next item. Perceived oral information may be intellectualized further with information available at the time and with information subsequently obtained. As such, the perception and interpretation of actual audible events are progressive processes that do not always accurately reflect the actual original event. The reliability of information perceived and interpretation is thus not always guaranteed. Next
What
item.
is it that you say in that paragraph?
Excuse me. The act of listening is an intellectual event, not just a passive listening. And to make sense of the sound you hear is a process by your brain and the information you process and the past information and the present information, and the presentation will come to you during a short subsequent time, because understanding of an event is a progressive process.
Does it mean in simple terms that two persons can listen to the same noise over a distance and have different views about the noise?
That is correct, my lady.
Because it's interpreted by the brain.
That's correct.
Paragraph 5.5.
The perception of sound by human beings may depend on a large amount of variables. First, I'm dividing into three categories: sound source sound spectrum, source sound intensity, etc. Second part, sound transmission, dependent on direct path, reflected path, number and types of intermediate sound barriers, ground conditions, temperature, atmospheric pressures, etc. Next point, listener, ambient noise level, in bracket, sound spectrum in time, close bracket, dependent on the state of hearing mechanism, the interpretation of sound perceived, in bracket, state of mind, and the reference information, sorry, I repeat that, state of mind and the reference information set available to the listener, close bracket. Next point. To be able to differentiate between a male and a female scream, one need to consider the following points. Point number one. Is it correct to reliably assume that without exception, all male screams sound the same? Point number two. Is it correct to reliably assume that without exception, all female screams sound the same? Next point. Is it correct to reliably assume that without exception, a female scream cannot sound like a male scream, or vice versa? Next point. While it is possible to differentiate human oral perception of a typical male and a typical female scream with or without visual correlations, we have found no reliable studies or evidence to support that assumptions stated in 5.6.1 to 5.6.3 above are indeed correct. And this refers to 3 points made correct previously.
What does that mean in simple terms?
That although typically one can differentiate a male and female scream, but one cannot say reliably without exception, one can always say it's a male or female scream.
5.8.
In addition to the certainty stated in 5.6 and 5.7, real-world scientific modeling and analysis are only basic way of attempting to explain the complex event of sound transmission. The modeling process excludes the possibility of 100% reproduction of original sound source and the perception of sound from a listener's perspective.
Are you saying in that is that though you can scientifically approach this, yes, it is not exact because you can't replicate the human interpretation?
Apart from that, also a real actual condition that when sound happened.
You can never replicate the actual conditions.
That's correct, my lady.
5.9.
From my experience and the past researches, typical human screams recorded are between 110 dBA to 120 dBA. For the purpose of this modeling exercise, I shall use an average value of 110 dBA. The next point is analysis. Would you like me to read through? The purpose of this report is to attempt to answer the 2 questions posed to PAC, that's Pro-Acoustic Consulting Engineers, in 2.1 and 2.2. In addition to the question regarding the reliability of human perception stated in section 5 above, a basic scientific modeling process may be used to assist in furthering the understanding of the sound transmission. The modeling process is basic due to the fact that a mathematical model can only be used to describe and simulate possible original sound transmission. It is impossible to replicate the highly complex nature of sound transmission under the original conditions. It is necessary to take the following factors into account: the location of sound source and the listeners, the environment of the sound source and the listeners, what are the possible sound transmission barriers if the listeners do not have a direct line of sight to the sound source. Other meteorological factors and the ground conditions are stated in 5.5.2 above. Next, would you like me to carry on because it's still right? Okay. The possible sound attenuation between the sound source and the listeners at 80 meters is 11.1 if it's scenario number 1. If the sound source emanated from the toilet with a closed door and a window. Subpoint to this section.
You mean a closed window?
With a closed window, yes. May I continue? Thank you. Sound attenuation at the sound source site. A closed toilet window offers an estimated 25 dB sound attenuation average over the mid frequencies.
What does that mean? Meaning if a sound was 100 dB and it goes through the window that's closed, what would it be on the other side?
We will measure 75 dBA at 1 meter away from the window. Next point, a closed toilet door with a second sound path through the open bathroom window, but attenuated by an estimated of 29 dB average over the mid frequencies through the closed door and the small opening of the window. Second subpoint, sound transmission. The model result indicates that for a sound signal to travel through 80 meters airspace between the source of the sound and the listener position, the sound would have attenuated by between 37 and 39 dB average over mid-frequencies. Next up point, this would have depended on variables such as ground conditions, for example, grassland or hard ground conditions, temperature, humidity, atmospheric pressure, wind, etc. at the time of the event. Next subpoint, sound attenuation at the listener's side. Subpoint, no further sound attenuation if standing on a balcony. Next subpoint, open balcony door with a limited opening into the bedroom. The expected sound attenuation between outside and inside the bedroom is in the order of 3 to 5 dB average over the mid-frequencies. Next point, sound attenuation in this scenario. Between 62 dB standing on the balcony to 69 dB listening in the bedroom, average over mid-frequencies. The main source of sound would be transmitted through the toilet window. I'm going to progress to the next scenario, number 2. If the sound source emanated from the bathroom with an open window, sound attenuation at the sound source side, the sound source in the bathroom would attenuate by an estimated 9 dB average over the mid-frequencies through the open bathroom window. Next point, sound transmission. The model results indicate that for a sound signal to travel 80 dB airspace between the source of the sound and the listening position, the sound would have attenuated by between 37 and 39 dB average over the mid-frequencies. Next point, this would have depended on variables such as the ground conditions, for example, grassland or hard ground conditions, temperature, humidity, atmospheric pressure, wind, etc. at the time of the event. Next subpoint, sound attenuation at the listener side. Subpoint, no further sound transmission if standing on the balcony. Next subpoint, open balcony door with a limited opening into the bedroom. The expected sound attenuation between outside and inside the bedroom is in the order of 3 to 5 dB average over the mid-frequencies. Concluding point for this scenario, total attenuation in this scenario, between 46 dB listening on the balcony to 53 dB listening in the bedroom. Attenuation average over the mid-frequencies. Next scenario, if the sound source emanated from the balcony. Subpoint, sound attenuation at the sound source side. Subpoint, depending where the sound source was standing, sound source at the balcony may or may not have a direct line of sight to the balcony of the house at 80 meters away. The possible sound attenuation at the source may vary between 0 to 15 dB average over the mid-frequencies. Sound transmission. The model's result indicates that for a sound signal to travel through the 80-meter airspace between the source of the sound and the listener's position, the sound would have attenuated by between 37 and 39 dB average over the mid-frequencies. This would have depended on variables such as ground conditions, for example, grassland, hard ground conditions, temperature, humidity, atmospheric pressure, wind, etc. at the time of the event. Next point, sound attenuation at the listener's side. Subpoint, no further sound attenuation if standing on the balcony. Next subpoint, open balcony door with a limited opening into the bedroom. The expected sound attenuation between outside and inside the bedroom is in the order of 3 to 5 dB average over the mid-frequencies. The concluding point for this scenario, total sound attenuation in this scenario between 37 dB listening on the balcony to 59 dB, to 59 dB listening in the bedroom. Attenuation average over mid-frequencies.
Well, anyway, moving on into the 177 meters, would this be an opportune time for the adjournment?
We take our lunch adjournment. Court will adjourn.
The arrived at
Is the witness, you still under oath, sir?
Yes.
Thank you very much.
Thank you, my lady.
Yes, Mr. Rowe.
Mr. Lynn, we now at page 11.
Yes.
And dealing now with the possible sound attenuation between the sound source and listeners at the approximate 177 meters away.
Yes. Should I continue?
Yep.
Scenario number 1. If the sound source emanates from the toilet with a closed door and a window, sound attenuation at the sound source site, closed toilet window, offers an estimated 25 dB sound attenuation averaged over the mid-frequencies. Closed toilet door with a second sound path through the open bathroom window, but attenuated by an estimated of 29 dB averaged over mid-frequencies through the closed door and the small opening of the window. Sound transmission. The model result indicates that for a sound signal to travel through 177 meters airspace between the source of the sound and the listening position, the sound would have attenuated by between 43 and 47 dB, averaged over the mid-frequencies. Next point. This would have depended on variables such as the ground conditions, for example, grassland, hard ground conditions, temperature, humidity, atmospheric pressure, wind, etc. at the time of the event. Next point, at the listener's side, subpoint, no further sound attenuation if standing on the balcony. Second subpoint, open or close balcony door not in a direct line of sight to the sound source. If open, the sound attenuation through the balcony door not in a line of sight is estimated to be 20 dB at mid frequencies. If the door is closed, an estimated 35 dB sound attenuation averaged over the mid frequencies is expected. Subpoint, open or close window facing the sound source with a limited opening into the bedroom. If the window was open, an estimated 3 dB sound attenuation average over the mid frequencies can be expected. If the window was closed, an estimated sound attenuation of 30 dB averaged over the mid frequencies can be expected. Concluding point for this scenario, total sound attenuation in this scenario, between 68 dB listening on the balcony to 102 dB attenuation listening in the bedroom with a window facing the bathroom and the window closed, average over the mid frequencies. Next scenario, if the sound source emanated from the bathroom with the open window, sound attenuation at the sound source side, the sound source in the bathroom would attenuate by approximately 9 dB average over the mid frequencies through the open bathroom window. Sound transmission. The model result indicate that for a sound signal to travel through the 177-meter airspace between the source of the sound and the listener's position, the sound would have attenuated by between 43 and 47 dB, average over the mid frequencies. Next point, this would have depended on variables such as the ground conditions, example, grassland or hard ground conditions, temperature, humidity, atmospheric pressure, wind, etc. at the time of the event. Next point, at the listener's side, no further sound attenuation if standing on the balcony. Next point, open or close balcony door not in a direct line of sight on the sound source, to the sound source. If open, the sound attenuation through the balcony door not in a line of sight is estimated to be 20 dB, averaged over the mid frequencies. If the door is closed, an estimated 35 dB sound attenuation average over the mid frequencies is expected. Next subpoint, open or close window facing the sound source with a limited opening into the bedroom. If the window was open, an estimated 3 dB sound attenuation average over the mid frequencies can be expected. If the window was closed, an estimated sound attenuation of 30 dB average over the mid frequencies can be expected. Concluding point for this scenario, total sound attenuation in this scenario, between 52 dB listening on the balcony to 86 dB listening in the bedroom with the window facing bathroom and the window closed, average over the mid frequencies. Next scenario, if the sound source emanated from the balcony, sound attenuation at the sound source side, subpoint, depending where the sound source was standing. Sound source at the balcony may or may not have a direct line of sight to the balcony of the house at 177 meters away. The possible sound attenuation at the source may vary between 0 to 15 dB, average over the mid frequencies. Next point, sound transmission. The model result indicate that for a sound signal to travel through the 177-meter airspace between the source of the sound and the listener's position, the sound would have attenuated by between 43 and 47 dB, average over the mid frequencies. This would have depended on variables such as the ground conditions, for example, grassland, hard ground conditions, temperature, humidity, atmospheric pressure, wind, etc. at the time of the event. Next point, at the listener's side, subpoint, no further sound attenuation if standing on a balcony. Next subpoint, open or close balcony door not in a direct line of sight to the sound source. If open, the sound attenuation through the balcony door, not in a line of sight, is estimated to be 20 dB average over the mid-frequency. If the door is closed, an estimated 35 dB sound attenuation average over the mid-frequencies is expected. Next subpoint, open or close window facing the sound source. With a limited opening into the bedroom, if the window was open, an estimated 3 dB sound attenuation average over the mid-frequencies can be expected. If the window was closed, an estimated sound attenuation of 30 dB average over the mid-frequencies can be expected. Concluding point for this scenario, total sound attenuation in this scenario between 43 dB listening on the balcony to 92 dB listening in the bedroom with a window facing bathroom and the window closed, average over the mid-frequencies. Shall I continue?
Thank you.
Expected sound level at plus minus 80 meters away. With the above analysis, based on an average human screaming level of 110 dBA. Subpoint. If the sound source emanated from the toilet, the expected sound levels are: on the balcony, range between 46 dBA to 48 dBA. In the bedroom, range between 41 dBA to 45 dBA. Next point. If the sound source emanated from the bathroom, the expected sound levels are: on the balcony, range between 62 dBA to 64 dBA. In the bedroom, range between 57 dBA to 61 dBA. Next scenario, next point. If the sound source emanated from the balcony, the expected sound levels are: on the balcony, range between 56 dBA to 73 dBA. In the bedroom, range between 51 dBA to 68 dBA. Expected sound level at plus minus 177 meters away. With above analysis, based on an average human scream level of 110 dBA. If the sound source emanated from the toilet, the expected sound levels are: on the balcony, range between 38 dBA to 42 dBA. In the bedroom, range between 8 dBA to 22 dBA. If the sound source emanated from the bathroom, the expected sound levels are: on the balcony, range between 54 dBA to 58 dBA. In the bedroom, range between 24 dBA to 38 dBA. If the sound source emanated from the balcony, the expected sound levels are: on the balcony, range between 48 dBA to 67 dBA. In the bedroom, between 18 dBA to 47 dBA. From my experience, as typically measured in similar quiet luxury housing estates, the background or ambient noise level inside or on the balcony of the listener's house in the early hours of the morning will be in a range between 20 dBA and 45 dBA. Now, can one reliably differentiate between a male and a female scream at a distance of 80 meters and 170 meters? Can one reliably discern the emotion of a scream from about 80 and 177 meters away, respectively? At plus minus 80 meters away, if the sound emanated from the toilet, subpoint. If the listeners were on the balcony, a scream emanating from the toilet at source can range from 46 dBA to 48 dBA, based on ambient noise level at the listening's location of between 20 dBA to 45 dBA. Thus, the sound is in a range of audible and intelligible. Next point. If the listeners were in the bedroom, A scream emanating from the toilet at source can range from 41 dBA to 45 dBA. Based on the ambient noise level at the listener's location of between 20 dBA to 45 dBA, the sound can range from audible and possibly intelligible to audible and intelligible. Second scenario, if the sound emanated from the bathroom, if the listeners were on the balcony, a scream emanating from the bathroom at source can range from 62 dBA to 64 dBA. Based on the ambient noise level at the listener's location of between 20 dBA to 45 dBA, the sound is in the range of audible and intelligible. Last scenario, if the listeners were in the bedroom, a scream emanating from the bathroom at source can range from 57 dBA to 61 dBA. Based on the ambient noise level at the listener's location of between 20 dBA to 45 dBA, the sound is in the range of audible and intelligible. Last scenario, if the sound emanates from a balcony. If the listeners were on the balcony, a scream emanating from the balcony at source can range from 56 dBA to 73 dBA. Based on the ambient noise level at the listener's location between 20 dBA to 45 dBA, the sound can range from audible and intelligible to very audible and intelligible. If the listeners were in the bedroom, a scream emanating from the balcony at source can range from 51 dBA to 68 dBA. Based on the ambient noise level at the listener's location of between 20 dBA to 45 dBA, the sound is in the range of audible and intelligible. At plus minus 177 meters away, if the sound emanated from the toilet, if the listeners were on the balcony, a scream from the toilet at source can range from 38 dBA to 42 dBA. Based on the ambient noise level at the listener's location between 20 dBA to 45 dBA, the sound is in the range of audible and possibly intelligible. If the listeners were in the bedroom, a scream from the toilet at source can range from 8 dBA to 22 dBA. Based on the ambient noise level at the listener's location of between 20 dBA to 45 dBA, the sound can range from not audible to extremely unlikely to be audible. If the sound emanated from the bathroom, if the listeners was on the balcony, a scream emanating from the bathroom at source can range from 54 dBA to 58 dBA. Based on the ambient noise level at the listener's location of between 20 dBA to 45 dBA, the sound is in the range of audible and intelligible. If the listeners were in the bedroom, a scream emanating from the bathroom at source can range from 24 dBA to 38 dBA. Based on the ambient noise level at the listener's location of between 20 dBA to 45 dBA, the sound can range from very unlikely to be audible to audible and possibly intelligible. If the sound emanated from the balcony, if the listeners were on the balcony, a scream emanating from the balcony at source can range from 48 dBA to 67 dBA. Based on the ambient noise level at the listener's location of between 20 dBA to 45 dBA, the sound is in the range of audible and intelligible. If the listeners were in the bedroom, a scream emanating from the balcony at source can range from 18 dBA to 47 dBA. Based on the ambient noise level at the listener's location of between 20 dBA to 45 dBA, the sound can range from extremely unlikely to be audible to audible and intelligible. The objective basic scientific process stated above indicates that the listeners may have heard a scream at 80 meters away, irrespective if the scream was from the toilet, the bathroom, or the balcony. However, at 177 meters away, if the scream was from the toilet, it is very unlikely that a listener can hear the scream, let alone interpret the sound source reliably. If the screams were from the bathroom, the listeners may have heard a scream and may possibly be able to interpret the sound under certain conditions. The above illustrates that due to the large range of variables, a range of possible results may be expected. It is not possible that one can model the original event with absolute reliability. It is demonstrated above and summarized in the result summary below to what extent a scream can be audible and to what extent a scream could be intelligible. The last point, as the act of listening is subjective and based on interpretation, the question whether a person could reliably discern emotions and differentiate between a male and a female scream would be within the domain of the court. The aim of this report is to demonstrate on a scientific basis, although not exact, and based on my experience, to what extent a scream could be audible and or intelligible, and whether the listener's interpretation may not be reliable, as set out in the result summary below.
And then on the next page, you go to the, it's really summarizing what you've said, the result summaries. You can just look at that.
Okay.
In the summary, you deal with the sound source locations. 1, the toilet, 2, the bathroom, and 3, the balcony. And then where the listeners would be at 80 meters away on the balcony and in the bedroom, and at 177 meters away on the balcony and in the bedroom.
Yes.
Just go through that.
Okay. When the sound source is in the toilet and the source side, at 80 meters away, expected range on the balcony at the listener's side is 46 dBA, which is audible and intelligible, to 48 dBA, audible and intelligible. If the listener is in the bedroom, the range will be 41 dBA, which is audible and possibly intelligible, to 45 dBA, audible and intelligible. However, at 177 meters away, the expected range heard at the listener position on the balcony is from 38 dBA, which is audible and possibly intelligible, to 42 dBA, which is audible and possibly intelligible. If the listener is in the bedroom, the range of sound will be between 8 dBA, which is not audible, to 22 dBA, which is extremely unlikely to be audible. At this point, I'd like to bring to attention that this result is based on ambient noise level. In the absence of ambient noise level, interpretation could be different. However, there is ambient noise level present. And we stated above, on the result summary, the source average is 110 dBA. The ambient noise level is 20 to 45 dBA, and they must be used as a reference.
You did not take into account at all possibility of dogs barking?
I think we mentioned that in one of the paragraphs previously. Where was
And then may I ask for a very short adjournment again dealing with the recording, just to make sure that everything is being recorded properly. She just needs an opportunity to listen to the recording and ensure.
We'll take a short break.
in the toilet, if you can go to, in the summary, the source in the bathroom.
Yes. If the sound source was from the bathroom, at 80 meters away, if the listener is standing on the balcony, the range will be between 62 dBA, which is audible and intelligible, up to 64 dBA, which is audible and intelligible. If the listeners are in the bedroom, the range will be between 57 dBA to 61 dBA. Sorry, the 57 dBA will be audible and intelligible. 61 dBA will also be audible and intelligible. At 177 meters away, if the listeners are on the balcony, the range will be between 54 dBA, which is audible and intelligible, to 58 dBA, audible and intelligible. If the listeners are in the bedroom, the range will be between 24 dBA, which is very unlikely to be audible, to 38 dBA, audible and possibly intelligible. If the sound source was from the balcony, at 80 meters away, if the listeners were on the balcony, the range would be between 56 dBA, which is audible and intelligible, to 73 dBA, which is very audible and intelligible. If the listeners were in the bedroom, the range would be between 51 dBA, which is audible and intelligible, to 68 dBA, which is audible and intelligible. At 177 meters away, if the listeners were on the balcony, the sound will be from 48 dBA, which is audible and maybe intelligible, to 67 dBA, very audible and intelligible. If listeners were in the bedroom, the sound range will be between 18 dBA, which is extremely unlikely to be audible, to 47 dBA, which is audible and intelligible.
Now, you made reference throughout to dBAs. Do you have any instrument that would assist in measuring the dBA?
Yes,
or the decibels?
I brought along a professional sound level meter, which is just been calibrated.
What meter is that? I'm sorry, Mr. Lee.
A sound level meter, which is a professional meter. This one is classified as type 1 or class 1 meter, by just being calibrated on 13th of May by national authorities, the calibration authorities. And this can show the level we're hearing at the moment, and it actually can show the actual number and what we're hearing as a reference.
So, for instance, if I'm not talking, what would it register there at the moment?
I'm now going to measure the ambient noise level of this court. If I could request everybody just keep quiet for 2 seconds. With the typing, I could hear the ambient noise level is 38 dBA, but it's very faint.
Is that 38?
It's 38, yeah. And I think for the purpose of it will be easier for my lady to see, I've brought along a much bigger version, which is not the calibrated meter, but it's being calibrated quite closely, resemble a professional meter, what a professional meter will show. So I think that it's probably easier for you to see as a reference.
So if you maybe can assist the court, you're talking and just say what the dB is then on this instrument, if you're talking.
I'm talking softly like this at my position. Obviously, I have to explain that the level of measurement is dependent on who is measuring. Obviously, I'm speaking from here now. The meter is quite close to me. So at your listening position, sound will be softer. So what I'll be measuring at your position will be softer than what is showing here. But right now, at this position, if I'm talking here, about a meter away, I'm talking softly at the moment, which is about 47, 52, 53, 47, 49, 50, 51, 50.
And where I'm standing here, for instance, and I'm talking to you now, what would that register?
Can you continue for?
Well, I will have to repeat the question or something.
Please.
Just to get a register.
About 45. 45.
Just to give the court an indication what we're talking about.
Yes.
But that's the type of instrument that you obviously use the professional one. But is that widely used in the industry?
Well, the professional meter is widely used in industry, and for certification reasons, for legal reasons, has to be a Type 1 calibrated meter. However, we use this for illustration purposes, just for easier to understand. And so also easier to illustrate that the sound is not absolute in terms of level. It changes according to time all the time. So as I'm speaking now, you can see the meter varying all the time.
As you're speaking now, what does it show when you're speaking?
If I'm speaking now, it's about between 60 to 70 dBA. That's a typical noise level in the open plane office environment.
Thank you, my lady. I have no further questions.
Thank you very much, Mr. Roo. Yes, Mr. Nell?
Please, good lady, learned assessors. We received this report that's of a very technical nature when the witness stepped into the box. Although I don't foresee hours of cross-examination, my lady, I do need time to go through this report, consult with somebody, my lady. So I need time. Could we perhaps have the adjournment, and I'll be ready to proceed with cross-examination tomorrow at 9:30.
I think it's a reasonable request. Yes, Mr. Roo?
I have no submission. Thank you, my lady. Thank you.
Did you say 9 or 9:30?
9:30, my lady.
9:30.
Yes.
We'll resume tomorrow morning at 9:30.
As a good pleases.